Good afternoon, everybody. Thank you for joining us today as we have a conversation about the Ohio Supreme Court's tolling order. We are super fortunate today to have two great lawyers to talk to you regarding the civil and the criminal law implications of this. We have Brad Wolfe to talk to us about the criminal implications. Brad is a lawyer at Friedman and Nemecek. And we have Michael Meuti. Michael is going to be talking about the civil implications, and he is a lawyer at Benesch. To both of you, thank you so much for joining us on short notice, and we really appreciate your insight. First, let's just kind of start with a background and lay of the land. How did we get to this point in terms of the Ohio Supreme Court issuing this order? Brad, could you start with that?
Absolutely. Good afternoon, Ashley and Michael. It's great to be here with you both. So just as some background information, on March 27th, House Bill 197 was passed by the General Assembly. And this provides various types of emergency relief to Ohioans during this pandemic. It does a number of things, such as waiving state testing requirements for the year. It extends the removal period for professional licenses, the income tax deadline. And relevant to today's discussion, it tolls criminal, civil, and administrative statutes of limitation under the Ohio Revised Code, so statutory deadlines that were set to expire on or after March 9th through July 30th of this year, or on the date which the emergency ends, whichever is sooner. Now, because the General Assembly cannot toll time requirements that have been established by the Supreme Court of Ohio, the court issued an order to toll the time requirements of its own rules or non-statutory rules, which also would have expired March 9th through July 30th, or again, whenever the emergency ends, if it's before July 30th. So as an example, if a deadline were to occur today on April 6th, which is 28 days after the effective date of the order, the new deadline for whatever that deadline was would occur 28 days after this tolling order is lifted, whenever that is. And what the court's order specifically tolls are time requirements, which are imposed and seen throughout the Ohio Code of Judicial Conduct, the Ohio Rules of Civil, Criminal, Juvenile, and Appellate Procedure, the Rules of Evidence, Professional Conduct, Traffic Rules, and a number of other sets of rules. And time requirements are actually defined as time for all filings, including pleadings, appeals, deadlines, and other directives related to time. So the court's order is meant to complement House Bill 197, which again focuses on tolling statutory timelines, and both are intended to facilitate essential operations of the court, but in a way that mitigates the spread of the virus.
Thank you, Brad. Michael, from a civil perspective, in terms of statute of limitations, expert reports, dispositive motions, what's your impression of that from the order, and maybe more pertinent, how are judges approaching it?
So one important thing to note about the order is that it's written so that it applies only to deadlines that would occur during the tolling period. So anything between March 9th as a starting point, and then either July 30th or whenever the emergency order issued by the governor is lifted, whichever of those two comes first. So it does not affect any deadlines falling outside of that tolling period. And we can talk in a minute about some of the odd little wrinkles that may create. Another thing to note is that it does not necessarily suspend hearings. So if you have a hearing on calendar, the order doesn't automatically take that off calendar. It says that the court may do that, and it says that the court may employ technology, either video conferencing or teleconferencing, in order to conduct the hearing, but it doesn't require the court to do so, although it does require lower courts to comply with the social distancing requirements that the state has otherwise put into effect. So that's kind of the broad effect in civil cases. Another thing to note is that neither the House bill nor the Supreme Court's order prevents a party from doing anything while the tolling period is in effect. So if you have a lawsuit that you wish to file, you don't have to wait until July 30th to file it. You can file it now. Of course, all deadlines for responding to the complaint and so on will be tolled during that period, unless a court orders otherwise. And that brings me to another important aspect of the order. The order creates a default rule. It's not a universal rule. Any court in any case may issue an order superseding the effect of the tolling order. So as to say that it could say, look, I set it, a judge may say, I set a case schedule before, and I intend to proceed with that case schedule, notwithstanding the Supreme Court's order.
And if I can just add to that, that's a good point, obviously, that the order authorizes lower courts the authority to waive any requirement that a party must appear in person. I was fortunate enough to speak with Justice Michael Donnelly this morning. And first of all, he indicated that while Chief Justice O'Connor asked each justice for their respective input, that she deserves immense credit for creating this order. And Justice Donnelly is particularly pleased with that exact language in subsection G that Michael was referring to, which advises courts to adhere to the tolling of time requirements, but also gives authority to allow filings to be made in accordance with existing rules, but to err on the side of the spirit and intent of the order, which is obviously safety when doing so. So ultimately, the courts have been given discretion, but this order urges the use of appropriate judgment and to consider recommendations from the Ohio Department of Health.
I know we're going to get into in a little bit the uniformity or maybe the lack of uniformity that we're seeing across Northeast Ohio and across the state. But before we do that, I wanted to mention one thing for our guests. There is a Q&A function as a part of this webinar. And so you can submit a question that I will present to Mike and Brad. We did just get our first question. So I want to ask that real quick. Michael, you might have gotten into it a little bit, but I just want to make sure that we address the question fully. So the question is, are court set discovery deadlines that occur within the tolling period in civil cases automatically tolled? And also the question asks regarding dispositive motion deadlines, or is leave from the assigned judge required?
So as I read the order, anything set before the tolling order went into effect, so any deadline set before March 9th, that will be taken off count. All of those are gone. That said, a court can issue an order saying, as I mentioned before, I'd issued a scheduling order, I intend to stick with it. Or alternatively, a judge could issue a scheduling order saying, I'd issued a scheduling order before, the Ohio Supreme Court has issued its order, and now I am tweaking my scheduling order to set the following dates certain. So any deadline previously set will be tolled during the pendency of the tolling period, but a court can easily undo that by entering an order now.
Question for both of you, and we'll start with Brad. What do you think we are going to see, or are we seeing, with regard to how local judges are interpreting the order and applying the order?
Sure. So just recently, the 11th District Court of Appeals actually issued an order acknowledging the tolling order, but they made clear that any new appeal filed in particular would be processed for decision as before the tolling order, and that previously issued scheduling orders would not be tolled unless a party, clerk of court, or court reporter moves for a COVID-19 related extension of time. So that's arguably different than the 8th District, for example, that although is conducting court business as usual through April 30th, they've suspended all oral arguments, they've converted them to non-oral submissions. a party can request an oral argument in writing for a later date. But I think judges in general have either been interpreting the order as, this does not stop the operation of courts, which I believe is accurate. It simply removes the function of time limitations and deadlines temporarily. I know a number of judges who have read the order and the bill and deduced that, while the intent may be to hold all proceedings, that just isn't happening. So there seems to be some confusion. I think relying on, again, the intent of the order in the first place would make sense, but different courts have obviously done different things to this point.
Michael, what do you think about how judges are applying the order, or have you had any instances of note?
So I had the opportunity to speak with Judge Phil Calabrese on the Cuyahoga Court of Common Pleas earlier, and he said he recognizes that there are some potential wrinkles that the that the order may create. He said ultimately the touchstone here is going to be reasonableness. If it makes sense to proceed with a given deadline in a case, then proceed with it. This isn't a stay order. It doesn't completely press pause on everything that a court does. And neither lawyers nor judges should be viewing it as a 3-month or 4-month vacation where nothing will happen. But at the same time, if it's not reasonable to press forward with a particular act in a case, then the party shouldn't be pushing for it. Ultimately, I think what Judge Calabrese is expecting, and I think what most other judges will expect as well, is that the parties work together to accomplish as much as they can during this difficult period, so that we're not left when the tolling period ends with an absolute onslaught of deadlines. All of the cases filed in the intervening period, plus all the cases that were already pending, plus all the new cases that will be filed, deadlines piling one on top of the other, on top of the other, on top of the other. That's a situation that nobody wants to be in, judges or lawyers alike.
Yeah, that's a great point. And this obviously applies civilly as well, but criminally, there could very well be a breaking of the dam, if you will, when the order is lifted. Many people who want to get to their day in court immediately, especially those who are sitting in jail, which I think we'll talk about momentarily. But this may create a very big logistical issue, a need for larger jury pools, perhaps asking retired judges to return to the bench. And something else to consider is a lawyer's ability to even adequately prepare for trial right now, given the obvious obstacle in meeting with witnesses or even meeting with your own client, whether he or she is in jail or even out. Ashley, you and I are on the COVID-19 task force here at the CMBA, and we're actively discussing these issues with many local judges and practitioners. So there's definitely awareness, but when the order is lifted, we need to be prepared.
Absolutely. We are getting a couple more questions, so I want to get to some of those. Michael, you are a fan favorite. It specifically references you. Has Michael seen anything in the orders that would prevent parties from conducting remote depositions during the tolling period?
So no, I haven't. And that, I think, it exemplifies the difference between this order, which sets a tolling period, versus an order, which I've seen in other courts, some federal courts, including one in Florida, that stay everything. So that during the intervening period there, nothing will happen. Here, parties can and should accomplish it as much as they can. They can issue written discovery, although the deadline for responding will technically be told under the provisions of the tolling order. The parties should negotiate amongst themselves as to what deadline they can agree to, and thereby keep a case moving. And there's nothing whatsoever that would prevent parties from conducting depositions in the meanwhile, either telephonically or through video conferencing.
A lot of what we are talking about and what you guys are talking about today strikes me as a delicate balance. From a criminal perspective, Brad, can you hit on some of the constitutional rights that are at play as we try to balance all of these interests?
Absolutely. And one other point to the last question in terms of being creative right now, you have the Ohio Supreme Court, who I believe this week will be hearing oral arguments virtually. So, people are using technology to take advantage of this. But when we talk about constitutional rights, especially, to a speedy trial, all this needs to be weighed with public safety. But as mentioned, we have many people who are incarcerated. They cannot post bond. And there's an argument that this extension of time for their day in court is unjust. And in some cases, it can be to their benefit when you look at some of the efforts of many courts, including Cuyahoga County Court of Common Pleas, to expedite some cases. Obviously, assuming people aren't just taking pleas to be done, but that reasonable resolutions are being offered and accepted. But it's a very delicate balance. And perhaps that's why there's a finite day of July 30th. I understand at some point in discussion of the House bill, they were considering as far out as December. But it's almost like a necessary evil. On one hand, we need to contain the virus, no question, stop the spread. This is as serious as it gets. By tolling time requirements, the courts are very much slowing the curve, I would hope. And on the other hand, we need to keep fighting for people's constitutional rights. And to that point, this is just Ohio. We don't know about what other states are doing to toll or take away other defendants' rights. But then again, Ohio is being praised internationally for its efforts. So I think it teaches us, and I got this from a much more experienced lawyer than me, but nothing is absolute. If we're learning anything from this situation, it's interesting how hard we fight to keep these rights when the pressure is off, but how easily they are taken away, understandably with good cause, but it's definitely a difficult balance.
We did just get another question, so I want to make sure that we try to hit all of these. So I don't know if you guys have the House bill in front of you or not, but the question is referencing Section 2210C. If you do, if you don't, that's okay. But it's asking about the interplay of the order and the bill with administrative agencies, if you guys have any insight into that.
Unfortunately, I've got nothing to offer there. My practice doesn't put me in front of administrative agencies very frequently, and I have not looked into what the implications are. My understanding of the statute is that any statutorily set deadline, anything that could be jurisdictional or could affect a court's or an administrative agency's ability to hear an issue, that is intended to be told. I would expect that just presses the same kind of a pause button for filing requirements in administrative agencies, the same as it does for court filing deadlines. But I do not know of whether any administrative agencies are intending to promulgate their own rules, further interpreting the House bill.
Yeah, and I would just echo that and again indicate that House Bill 197 clearly speaks to criminal, civil, and administrative statutes of limitation. And the Chief Justice's order covers a number of administrative bodies.
I think that we hit on this a little bit earlier, but I just want to make sure that we address it in case someone jumped on late, and I certainly don't want to not ask a question. There's a question about whether or not this supersedes scheduling orders from before March 9th. If either one of you want to just give an answer to that.
Michael, I think you answered this earlier.
Yeah, in civil cases, the answer will be yes.
Right, and that's right for criminal.
What do you guys think, and this is kind of getting a little bit into when we finally get through this or the worst of this, whatever that may be and whenever that may be, how are courts going to, or how do you think courts will approach trials and, things that have been, specifically trials that have been postponed? So let's say you have a trial that was set today and it's been postponed till July 1st, but of course there's going to be, a ton of other cases during that time because we're not having any jury trials. Any insight as to how courts may approach the scheduling of that?
So what my experience has been so far is everything's been kind of wait and see. We had one case that was in Montgomery County that was scheduled to go to trial in about a week and a half. And at first, the message we were getting was still hoping to go forward. Then we got the message, nope, that's not going to work. Let's try to reschedule. And we've been working with the judicial assistant ever since then to find dates in the fall that work for all of the parties. And we're going to agree to one of those dates and hope that the crisis has dissipated by then, only to revisit if we find out, unfortunately, that that is not the case.
That's right. And the CMBA COVID-19 task force, which I referenced, is actively discussing this very real possibility with many of the judges in Northern Ohio and beyond. And it could be a very big practical, I think the question used the word ripple effect. So to avoid that bottlenecking or that breaking of the dam, rather, we're starting the talks right now of how to best prepare for that.
Obviously, there's been a lot of uncertainty and a lot of bad that has come out of this situation. But I also think on a personal and professional level, we can all agree that there's been some good that's come out of it as well, in terms of our relationships and our families and our priorities, things like that. But how do you see this pandemic and specifically how Ohio has approached it? How do you see that changing the legal landscape in Ohio in maybe a positive way moving forward?
So it's absolutely correct. And Chief Justice O'Connor, she had said that this unprecedented crisis requires unique solutions for the short term and the long term. So, you know, you have the order, which advises the use of technology when appropriate. And when we talk about uniformity in our state and amongst the courts, you know, especially given the circumstance of not being able to meet with your client in jail, for example, if there's one silver lining, perhaps that issue of accommodating and fitting jails in particular with adequate video communications, that could be a benefit from this. When you talk about other changes in the legal landscape, I think just the general automation and efficiency, which we're all forced to kind of adapt to in real time right now, may continue. On different levels of this, you have Professor Jonathan Whitmer-Rich from Cleveland Marshall College of Law. He and two other law professors, I believe from Kentucky and Illinois, they're actually spearheading a national petition right now to permit this class's law school graduates from foregoing the bar exam and for lack of better words, simply becoming licensed into the profession upon graduating. Again, with the intent to avoid the mass gathering of people. And this is going to continue for months. The state of Wisconsin, I believe, has a similar format right now upon graduation with certain stipulations. But there's a lot of untapped ground here that could result from this.
Michael, anything to add to that?
You know, one thing that I have found kind of heartening about the situation that we're all in is the number of communications I've gotten from opposing counsel that begin or conclude with, I hope you and your family are doing well right now. And, you know, I've always thought that the best part of the legal profession was the ability for people to recognize, hey, it's our job to disagree. That doesn't mean we need to be disagreeable about it. And I've seen a much greater focus on that recently. I think people are focusing much more about things that, on things that truly matter in their lives. And my hope is that in the day soon, God willing, when this all ends, that as we get back to normal, that we begin, or that we continue to recognize the best parts of the profession, and that we continue to put well-being of colleagues, of opposing counsel, of adversaries as a front and foremost concern, and put aside some of the sniping that is ultimately not very productive and doesn't help to advance the resolution of a dispute, and often not our clients' interests either.
Mm-hmm.
Well said. We did just get a question in that I think kind of goes to what we're talking about in terms of automation and improving processes. So there are courts throughout the state, and certainly there are some in Northeast Ohio that don't have e-filing or don't even accept fax filing. How does that work with this pandemic and the governor's order and social distancing? And do we think the individual had a follow-up question about whether or not the order or, the Supreme Court or some higher court could make this, mandatory?
So the order makes clear that technology should be used and considered when appropriate, when it doesn't take away the integrity of a proceeding. And as true as that is, I don't think there's anything like sitting next to your client in a sentencing. And I don't know how technology can fully replicate that. But again, this is unique circumstances. And in that type of case, I found cases or courts to be very receptive to continuing things farther out, especially when there's no pressing reason to do so. When you talk about what other courts can do locally, I know that the Willoughby Municipal Court, I believe they've just received a grant to actually facilitate more technology in their court. So if it's a function of resources, I understand there are measures courts can take to get the resources to do so. I think the other thing to consider from a practitioner standpoint is making a record. And if you're faced in a situation where a court's circumstances are not safe or adequate, I think you need to make that record. And I think now more than ever, the highest court here in Ohio is very much listening in to those types of issues.
We have about 3 minutes left, so I just want to leave each of you with the opportunity to hit any points that you didn't get to hit, or something that you just want to leave everyone with. And again, I thank you so much for joining us today.
So one thing that I'd like to conclude with, actually two things. First, I'd like to conclude with a word of thanks to the CMBA and everybody who's participating. You all have given me a reason to shower before 4 p.m. today, so thank you very much for that. But on a more serious note, one thing that we need to think about is the interplay between deadlines that will be tolled because they fall within the tolling period and deadlines that will not be tolled because they fall outside of the tolling period. There are going to be occasions in which the latter deadline that is not tolled is dependent upon something happening during the tolling period. And it's important for we as lawyers to be proactive, to spot those issues ahead of time, to work with opposing counsel, and then to approach the court in a problem-solving capacity so that we're able to avoid any of those things that start off as little wrinkles from snowballing into being giant scheduling problems. And that the need is especially acute given the inevitable backlog that's going to occur between once the stay is lifted for having all of the new deadlines kind of piling on to existing deadlines.
I would also like to thank the CMBA. Thank you, Ashley. Thank you, Michael. This is an important topic, and although it has to do with the tolling specifically, it's obviously part of a much larger issue that's unprecedented right now. I guess I would just say that I'm very grateful to live in this state right now with the way that the governor and the highest levels of government here have been approaching the pandemic. With that said, again, from the criminal point of view, there's definitely some balancing when you talk about people's constitutional rights and the tolling of time and what that means to somebody who's in jail and cannot post bond. With that said, perhaps it is a necessary evil to prevent a much larger a public health crisis from getting even worse. But I'm optimistic that Ohio in particular and our Supreme Court is very much so on the ball. And again, thank you.
Awesome. Well, I thank both of you again. I thank everyone for tuning in. Make sure that you follow the CMBA on their website, on their Facebook. This is going to be uploaded there, so you can go back and watch it if you want to check an answer or refresh on something, share it with your colleagues. And in the spirit of Michael, I hope everyone and their families are well and safe and happy and healthy. Thank you.
Thank you.
Thank you all.